Hello and welcome back. Part 1 of this analysis of Sharp's judgment dealt with the obvious misrepresentations she used to deny our harassment claims against Melanie Bing and Andy Lewis of the Quackometer. If you haven't watched it yet, I'd recommend you do so before continuing with this one. Part 2 focuses on the second application to reopen the appeal in defamation. In her deceitful disconstruction of the merits of that application, she again dismisses the video evidence we had submitted, using the same false reasoning she used to deny us an appeal against the harassment claims. She then moves on to dismiss the judgment of Monroe v. Hopkins we were relying on, saying, "It is not evidence, fresh or otherwise. It is a decision of the court of no relevance to these proceedings." Quite the contrary. It was a case about social media, about a couple of tweets, and how damaging to one's reputation a tweet that had been deleted after a mere 2 hours could be. Our case against Lewis and Bing include tweets that have been online for years. Also, during that particular case, the same barrister, Jonathan Price of Doughty Street Chambers, tried to argue that tweets are ephemeral. He used this ridiculous and misleading argument, which goes blatantly against the obvious facts, in our case too. But whereas the judge in the Monroe v. Hopkins case saw right through this absurdity and rightfully shot it down, the judge in our case, says Llewellyn, swallowed it hook, line and sinker. Sharp is clearly fine with two blatantly contradicting judgments based on a similar argument. That case also interestingly brought to the fore another important point. Says Llewellyn relied on part of the Defamation Act of 2013 in his judgment, even though that change in the law had not taken effect by the time we had started our proceedings, and therefore he should not have been allowed to rely on it, and yet he did. The law isn't a pick and mix buffet, well, at least it's not supposed to be. But Sharp, obviously, sees no problem with a judge playing fast and loose with the law, as says Llewellyn so clearly has. Sharp doesn't even mention additional evidence we had brought, like the fact Lewis uses the word claims in his other publications as the ordinary dictionary meaning expects him to, not as the absurd definition says Llewellyn made up in his judgment. But again, it seems once a judge has redefined a word, no matter how ludicrous that new definition is, we are now all stuck with it. Sharp then moves on to the issue of Simon's bias. She states that the fact that Simon LJ determined the first application for permission to appeal was no bar to his determining subsequent applications. Well, that's technically correct, except that Simon clearly showed bias against us at that first appeal. Take, for instance, his refusal to hear about the fact Barrister Jonathan Price of Doughty Street Chambers deliberately tampered with evidence in our case. Simon stated in court that is not a ground of appeal that you have raised, and he refused to listen to our arguments. In fact, we had most definitely raised this fraudulent act in our grounds at point 28, in our skeleton at points 91 to 98, and at point 17 of the document that was right in front of him at the time. Tampering with evidence is supposedly a very serious offence. So if judges are going to allow a barrister to get away with it, it is crucial to pretend as if we never raised that issue and trust that no one will bother to check the facts. This was just one of numerous reasons why we stated Simon was biased and should be recused from the case. However, here is the sole reason Sharp gave in her judgment for our request for recusal. What apparently provoked the allegations of bias was that the respondents be given opportunity to reply to the applicant's submissions. Not only was this never raised by us, it is absolutely preposterous, because asking the other side for their point of view shows the exact opposite of bias. That ridiculous reason didn't come out of thin air, by the way. It was the reason Simon gave himself for dismissing our accusations of bias against him. He couldn't use any of the points we actually raised, of course, because those showed clear bias. So he had to make one up. He had to lie in his judgment, and Sharp was only too happy to repeat that lie. Did she even bother to read our submission, or did she simply glance at the previous judgment before mirroring it in her own? Oh, speaking of judgments, Sharp is also completely comfortable with the fact that Simon is the only person to have decided if Simon was biased or not. Try using that logic if you ever find yourself in court and see how far you get. Finally, Sharp throws down the gauntlet. The applicants should understand that if any further applications are made directly or tangentially in connection with these proceedings and the issues considered in them, the court will be bound to consider making a civil restraint order. Oh, put the knife back in the drawer, Ms. Sharp. Seriously though, this is absolutely ludicrous. We have continuously pointed out that Melanie Bing, Andy Lewis, and their lawyers, Robert Dugans of Bryan Cave and Jonathan Price of Doughty Street Chambers, are clearly breaching a court order themselves when they refuse to hand over further damning evidence of the lies they spread about us to most of the big hitters. This was stated at paragraph 27b of our closing argument, paragraph 21 of our grounds of appeal, 33 of our appeal skeleton, 25 of our appeal hearing document, and paragraphs 20 to 22 of the most recent appeal document on harassment. All 4 judges who have dealt with this case have ignored this. In fact, since Sharp has now told us that our applications are hopeless and totally without merit, this means breaching a court order is not even worth submitting an application about. This leads us to the inevitable conclusion that court orders are meaningless and breaching them is of no consequence. Sharp's threat of issuing an order on us has to be seen in that context. This is but an empty threat because she can't possibly enforce an order on one party while allowing the other party to breach one, right? Well, if you still believe that, you still believe justice is impartial. In part 3, I'll give you my conclusions of this kangaroo court fiasco. Thank you for watching. Don't forget to like and subscribe, and I'll see you next time.